welcome to our Supreme Court case presentation on Engel versus Vitale, 1962 by Gary and I. Now, some basic background information. In New York, there was a state law that required all public schools to begin with the Pledge of Allegiance and a prayer, non-specific. It could be to the Christian God, it could be to Allah, it could be to Vishnu, whoever it could be, right? Where the students would recognize their dependence on God. And the law also allowed them to opt out of this prayer. But a parent sued the school on behalf of his children, saying that the law violated the Establishment Clause of the First Amendment, which forbids government from establishing an official religion or sponsoring religion in any way. And this law was made applicable to New York through the Due Process Clause of the 14th Amendment, in which no state can create or enforce any law that violates the privileges of the citizens of the United States. And in this case, Engel represents the parents and Vitale represents the state of New York. Now, what are the fundamental constitutional questions/issues in this case? Well, the most obvious one is, does this prayer violate the Establishment Clause of the First Amendment? Now, the ruling in the case was, yes, it did. The ruling was 6-1 in favor of Engel, and the court decided that the prayer was a violation of the Establishment Clause, which made it unconstitutional. Now, what was their reasoning behind this decision? The reasoning was that even though there was an opt-out clause, that did not make it constitutional, and that the purpose of the First Amendment was to prevent the government from interfering with religion, and therefore, them sponsoring a prayer was a violation of the Establishment Clause, and due to this, they ruled in favor of Engel. How did this impact future rulings? Well, this ruling in favor of no school-sponsored prayer reasserted the importance of separation between state and church, and it also banned school officials from making prayers an official part of public schools anywhere. And this case was one of the first of many to use the Establishment Clause to ban religious activities in public schools. Let's take a look at some similar cases. Now, Abington School District versus Schmidt, very similar to Engel, in which Pennsylvania had a law that required, each school day to open with a reading from the Pledge of Allegiance and the Bible. Get a little deja vu here. And this law allowed students to opt out if they wanted to. And much like Engel, the court actually cited them in this case by saying, this is unconstitutional, you can't do this, it's a violation of the Establishment Clause. Now, Santa Fe Independent School District versus Doe. Before football games, a couple members of the student body of a Texas high school would allow one of their classmates to give a address to the players and to the students, and it usually included a prayer. Now, even though attendance at this event was voluntary, 3 students sued the school, saying that the prayers violated the First Amendment. And the students' argument who were giving the prayers was that it wasn't school-sponsored because it was led by the student body, so it was all right. It didn't violate the First Amendment as it wasn't government-sponsored. But the court, however, said that it was actually school-sponsored since the loudspeakers were owned by the school. Therefore, it was a violation of the First Amendment. And that's about it. Those are our sources. I hope you enjoyed.